Hi, I'm Vivian Dempsey, and I teach the Writing Edge Bar Review course. I specialize in repeat takers of the California Bar and attorney bar applicants for whom the performance tests are of particular importance, since for attorney bars applicants, the performance tests are 40% of their entire score. So doing well or poorly on the performance test can make it or break it for the attorney bar applicants. Since most people don't really prepare for the performance test at all for various reasons, either they think it's futile or else they think that it's something that they know how to do in their real life, and therefore there's nothing to study, it comes as a big shock at how hard the performance tests actually are on the bar. And PTA on the February 2014 bar exam is a perfect example of that. What I want to do here is I want to go through the analysis of how I came up with this answer. So, you know, the bar exam is not about right or wrong, okay? There are gradations of better answers and worse answers, but what's important, I think, is for however you study for the performance test to be duplicable. That is, for you to be able to repeat it on the bar exam. So just looking at somebody else's answer doesn't tell you how they did it. So I'm going to try to unwind my thinking process on this exam and help you to do better, not on this exam obviously, but on the next one that you take. The most important places for you to look in a performance test are the assignment memo, the library, and any document in the file that was written by a lawyer that's pointed to or emphasized by the assignment memo. A lot of times the assignment memo will give you the 3 issues, okay? But a lot of times you just get the 3 issues from the library itself. So in PTB, for example, on this bar exam, the 3 cases were the 3 issues, and that was very, very straightforward and simple. That's a very common organizational structure for a performance test answer. Note, however, that the issues are not the same thing as the format, and issues have to be legal issues about which there is something in the library that discusses them. Okay, so in this performance test you had a bunch of signals which was difficult to resolve into a single organizational overview. The performance test assignment memo, the #1 place in importance to look for the issues, told you in the middle paragraph that the issues are, and it literally said 1, 2, 3, whether a commission is due, who, if anyone, should receive a commission, and whether the commission, if due, how much, I'm sorry, let me restate #3, and if a commission is due, how much the commission should be. So those are the 3. Whether commission is due at all, to whom, and how much. Okay. Those may have been the legal issues, but they were not the format for your answer. And I think that was a problem that many of you had. The next paragraph really fills in what your argument should be on those 3 issues in the above paragraph. And that is, we are supposed to argue that our client, Adams, has a superior claim to the commission because she was the procuring cause. Okay, so the 2 issues that are given in that paragraph are the procuring cause and that she had a superior claim. Okay, so there were 3 cases in the library, and your first impulse probably would have been to look to those 3 issues for the assignment memo. So let's examine those and see if they gave you, if they addressed all 3. Miss Adams is entitled to a commission, and how much that commission would be. Okay, so here's the 3 cases from the library: Quincy, Ellis, and AAA. Quincy is very useful because it defines procuring cause, and it says that procuring cause is a common law doctrine which is recognized in the state of Columbia, our state, and it says that the broker is entitled to a commission if she was the procuring cause of the ultimate sale and took all the steps that were materially necessary to effect that sale. And that's true even if the sale occurred after the broker was no longer representing the seller. The second case, Ellis, says that the broker is entitled to a commission unless the negotiations stopped and started and the negotiations that resumed were of a materially different nature than the previous negotiations. Okay, so negotiations stop, start, and are materially different in character from the prior negotiations. In that case, they would not be entitled to a commission. And the third case is AAA, and it says that procuring cause is not necessary for the broker to get a commission. The contract controls the right to get a commission. So the procuring cause is a common law doctrine, but the actual contract between the two parties trumps common law, and the contract controls. So whatever the contract says entitles the broker to a commission is going to be the thing that controls whether the broker gets a commission. And in the AAA case, the thing that entitled the broker to a commission was whether he referred the buyer to the seller. Referred. The AAA case goes on to talk about it and other similar vague terms like referred, to say that all of them, well, referred in particular means more than send or direct the buyer to the seller, and that contained within the contract term referred, implicit in it. Let me find the words because it was so beautiful. Okay, I found that place in the AAA case. It says, I love this, that such terms, such as referred, necessarily incorporate an unexpressed but inferentially essential requirement that the broker do more than merely send or direct the potential purchaser to the seller. And it goes on to say that there must be a minimally causal connection between what the broker did and the sale closing. Okay, so these are your three cases, and let's see how this would work plugging in the facts. Okay, so on Quincy, this is quite useful to us because we represent Adams, and she was the procuring cause. So Quincy not only found the client initially and put the client in touch with, the buyer initially and put the buyer in touch with the her client, Kustom's spas, but also she provided information, she got financing for the buyer, she did everything necessary to close the sale. It did close 3 months later after she stopped being the broker, but because she was both the procuring agent and had taken all the steps necessary, she's entitled to her full commission. The second one, Ellis, says that the broker is entitled to a commission if the negotiations that wound up closing the sale were essentially one continuous similar line of negotiations. If they stop and start and the new ones that start up again are materially different from the prior, then that would end the first broker's right to a commission. Here, the sale that closed was literally the same offer that Adams had written. So even though the negotiations did stop and start for 3 months, the offer that finally closed the sale was literally the one that was written by Adams in cooperation with the buyer. And so there was nothing different. It was exactly of the same character as the previous negotiations. And this further entitles Adams to a commission. The third case, AAA, says that procuring is not necessary. Being the procuring agent is not necessary to get a commission because what actually controls is the terms of the contract. So if the contract says that you are entitled to a commission if you referred the buyer to the client, then if you meet the meaning of that term referred, then you are going to get your commission. Smith, the closing broker, says that by making a phone call, leaving a voicemail message for the Kustom spa owner and saying, say, Midvale is still interested, why don't you give him a call? That was referring. Whereas, of course, Midvale and Kustom Spa knew each other and had been in intense negotiations prior to this. So lifting up the phone and making a voicemail message to say, hey, call him, is certainly not sufficient to meet the test for referred. AAA gives us the test for referred and says it has to be something more than simply sending or directing the buyer to the seller. And it finally concludes that the connection that the broker has to the deal closing has to be at least minimally causal. And here, even in Smith's own words, everything had already been done. There was nothing left for him to do. So this one's pro-Adams, this one's pro-Adams, this one's anti-Smith. Now, you could very easily, and probably did, organize your performance test around these three cases. Okay. To my way of thinking, it didn't really get into the third question, which is how much was the commission that was due. It really is mostly which one of them is entitled to a commission. Okay. Furthermore, these three cases aren't about the same factual problem that we are given. That is, our factual problem is two brokers are fighting over the same commission, and it's before an arbitrator. Okay. All three of these cases are about a broker and a client fighting. This is not the same circumstance. It's not two brokers fighting. Okay. And the very last paragraph of AA, as a matter of fact, it's in a footnote of AA. I messed up my page. Here it is. It really drops the bombshell that is a wake-up call for why these cases don't control. So listen to this. In a footnote, it says that the arbitration guidelines are inapposite here for two reasons. First, the case does not arise in the context of an arbitration. Second, those guidelines deal with disputes between brokers competing for the same commission, which is not the case here. So when you realize that the court is saying the guidelines don't apply to cases involving a dispute between a broker and a client, the opposite is also true, which is the cases involving a dispute between a broker and a client are inapposite in the arbitration guidelines. They aren't precedent. They are not controlling because they're not on the same subject. Okay. Now we can use them, and note that really a lot of this is terminology. This is defining probable cause, which is procuring cause, which is a term that we need. This is about the continuation of negotiations that have stopped, and this one is about the contract controlling when a commission is due and the term referred. So all three of them are useful to us in our factual problem, but they are not controlling authority. And not only that, but if you use these three, what are you going to do about the arbitration guidelines? The 8 factors in the arbitration guidelines, which is also in your library. It's hanging out there like a useless appendage. It doesn't have a place if you use this as the organization. So for all of those reasons, number one, I don't think this answers all three of those questions. Number two, these cases are not on the same subject as our factual problem. And number three, the red flag that the AAA case gives you, which is, yoo-hoo, these two things are different issues. Dispute between broker and client is different than conflict between two competing brokers. They're not the same issue. For all of those reasons, the actual, or let's just say the better organization, would have been using the arbitration guidelines. After all, what are they for? The arbitration guidelines. Okay? They are literally, here is the intro to the arbitration guidelines, also in your library. They are literally for disputes between two brokers. Okay, all brokers in the state have agreed to be bound by these, so they are controlling authority for both Adams and Smith. And listen to this, because it mirrors what the assignment memo is saying. It says about halfway down on the first page of the Columbia Association of Commissioned Brokers Guidelines, it often turns on the precise terms of the brokerage contract. That's AAA. Okay. It frequently involves the principle of procuring cause. That's our favorite doctrine because that favors Adams. Okay, so again, it's mirroring the same two issues that the assignment memo gave you. Okay, the procuring cause and the fact that contract terms trump common law, which is the procuring cause doctrine. Okay, so you can see how the two of them dovetail. Okay, they dovetail into each other. When you get to the broker evaluation form, which is 8 factors, okay, and it's even lined up so that you have this one's in favor of the intro broker, that's our client Adams, and this one's in favor of the closing broker, that would be Smith. So this is literally the evaluation form into which you can put the specific information about our situation and determine, is this pro-intro broker, that is our client, or pro-closing broker, and come up with an evaluation. Okay, so as the first page says, the following factors reflect common characteristics that arise during the course of such disputes and are intended to serve as guidance to the arbitrators to aid them in reaching their decision. Not all factors are useful or applicable in all cases, but those that are applicable are to be considered as a whole. The factors are not necessarily weighed equally, but the outcome should be determined by which one, given the equities of the situation, outweighs the other. Okay, so what we do then, instead of using these 3 as the structure for your answer, Quincy, Ellis, AAA, that's your whole answer, you use the arbitration factors and fold in where the case construes one of the factors. This is what I call a mothership. You're given a single structure. Okay, it almost always is multifactorial, and in this case there's 8 factors. You've got a single structure, and into that you put your other authorities where they fit. Okay, so it serves as the organization for your answer. Literally the entire universe for analyzing the problem fits within the mothership. And this is not something surprising or new. There have been mothership PTs, at least 7 of them, maybe 8 of them. So it's something that certainly other bar courses should be aware of, although I've never heard any of the other ones talk about this. Okay, so that means that our organization is going to be around the factors, and I'm going to stop the rolling the video now and put up those factors onto my whiteboard back here. So I've put up behind me the first 3 of the 8 factors in the arbitration guidelines, and look at this. The first one is that the broker first introduced the buyer to the seller. That's exactly what a procuring agent is, right? So the Quincy case fits right here. The Adams both introduced and took all steps necessary to effect the sale. The fact that it happened after her relationship terminated with Koster is of no consequence under the rule of this case. Okay? So the second one, the second factor, is that the closing broker, Smith, never showed the property to the buyer. Well, he didn't do anything. All he did was get Koster to sign a commission and make the one phone call. That was it. He said himself that there wasn't much left to do by the time he got involved in the deal. Okay, and so the AAA case, remember, says that there must be at least a minimal causal connection between what the broker does and the closing. And here, Smith, by his own admission, didn't do that. Okay, he thinks that leaving a phone message is referring, and it doesn't even meet the test of referring in the AAA case. The third of the factors, of the 8 factors, is that the well, how does it actually read? The closing broker wrote and submitted an offer on the property in behalf of the client that was substantially similar to the offer written by the intro broker. Well, that doesn't even fit our facts because the closing broker never made an offer here. He never wrote one. Why? Because the offer had already been written. It already existed. And he just went, oh, okay, all right, I'll just take that. And he also found out that an escrow account had already been opened. Okay, all of these things, of course, had been done by Adams. Okay, so in a sense, number 3 doesn't even apply because the closing broker didn't even write an offer that differed from Adams's offer. But in order to make it fit, I guess I changed it a little bit to say that the offers were substantially similar. They were in fact identical. The only change between the offer that Adams made and the offer that finally was accepted and resulted in the deal was a change in the date on the offer. Okay, so that's the third case. So factor 1, Quincy. Factor 2, AAA. Factor 3, Ellis. We then have the remaining factors, and of course they're not going to have as much reasoning in them because there's no cases going to them. So we'll just go through them a little more quickly. So factor 4 was that there was a significant time between the first broker showing the property and the closing broker closing the offer. Okay, well, there was actually 6 months between the time that Adams first showed the property and the time of the deal actually closing. But from the time that Adams stopped representing Koster to the closing was actually only 3 months. Not only that, but we're talking about a deal that was $1.75 million, which is a fairly large amount of money. And probably negotiations for deals that large do take longer. Third, really the only reason that it didn't close was because Koster was stubborn, and he had a certain idea in mind as to how much the property, his business was worth, and he wasn't going to deviate from that. Okay, so even though this appears to be 3 months, appears to be some amount of time between Adams ending her representation and the deal closing, there are some good reasons to mitigate that. The fifth factor was that the introductory broker gave significant information to the buyer. Well, Adams gave all the information to the buyer, actually went so far as to arrange financing, a loan for the buyer so that the buyer could afford to make an offer on the property. So she literally, this refers back to number 1, the first factor, she did everything for this sale to close. And certainly one of those things was that she gave significant information to the buyer about the deal. Okay. 6, the intro broker fails to maintain client contact. Well, there's a note on this factor in the arbitration guidelines that says that if it was the client that ended contact, that this really doesn't apply. It won't reflect negatively. And the client, Koster, because he was so stubborn about his price, was the one who stopped returning Adams's phone calls. So there were about 3 or 4 or 5 phone calls, and he never returned them, and she finally gave up and ran out the representation contract of 6 months. So this one really doesn't apply because of the Koster being the one that cut off contact. 7 is that the client, this is Koster, is dissatisfied with the introductory broker. Well, the arbitration guidelines give examples of what would be legitimate bases to be dissatisfied. Things like misrepresentations, dishonesty, really, malfeasance. And there was nothing that Adams did that rises to the level of malfeasance. Custer didn't like the fact that Adams couldn't come in with an offer of the amount that he wanted. That was it. So since this isn't really the kind of dissatisfaction that the arbitration guidelines contemplate, it too really doesn't apply in our situation. Okay. And so it doesn't reflect negatively on Adams. And lastly, the eighth factor, the closing broker never inquired as to whether or not there was another broker involved in the deal. And the guideline actually says that if he didn't inquire, then he's in danger of losing his commission entirely. And if he inquired late in the process, it could affect the amount of commission that he gets. And here, Smith, the closing broker, never inquired. And here he was coming in on literally the 11th hour of this negotiation, found the offer was already written, found that an escrow account was already opened, and never even said, gee, something else going on here? Somebody else involved here? Okay, and so he forecloses his ability to get a commission given the lack of his own due diligence. So this becomes then the universe of your answer. These are this is the organization for your answer, the 1, 2, 3, 4, 5, 6, 7, 8. Okay, and you see it really kind of clicks. It really fits very, very nicely into the arbitration factors. So that's my thinking on this performance test. I do think that if all you did was use the 3 cases and you had the right 3 case rules and reasoned, that this probably would still be a passing answer. Remember that the bar is comparatively graded. And so answers are going to pass that are not perfect. Okay, and the harder a PT is, the greater the disparity of answers from what I consider to be the target, the bullseye of what this answer should look like. So I'm sure that this would have been plenty good enough. But if you had this, you might have gotten a higher score. That's it for today. I hope you'll enjoy the other videos that I have up on YouTube under the Writing Edge. And if you have any more questions or would like to work with me for your next bar study, please give me a call at 510-644-3343.